A valid adoption under Hindu law essentially means that the adopted child is considered the natural child of the adoptive parents, severing all ties with their birth family from the date of adoption, granting them full rights to inherit property and participate in the adoptive family as if they were born into it. The child cannot marry anyone they couldn't have married before adoption within their birth family. Key points about valid adoption under Hindu law. 1. Complete severance from birth family. The adopted child is completely detached from their biological family and considered a full member of the adoptive family. 2. Inheritance rights. An adopted child has the same inheritance rights as a natural child of the adoptive parents. 3. No impact on pre-adoption property. Any property the child owned before adoption remains with them, subject to existing obligations. 4. Marriage restrictions. The adopted child cannot marry anyone within their birth family that they could not have married before adoption. And 5. Governing law. The Hindu Adoption and Maintenance Act, 1956 governs the legal aspects of adoption under Hindu law. The main effect of a valid adoption is to legally transfer a child from their birth family to their adoptive family. 1. Severed ties. The child's ties with their birth family are severed and replaced with new ties in their adoptive family. 2. Child status. The child is considered the natural child of their adoptive parents. 3. Child's rights. The child retains any rights they had before adoption, including property rights. 4. Marriage restrictions. The child cannot marry anyone they could not have married if they had remained in their birth family. 5. Adoption cannot be cancelled. A valid adoption cannot be cancelled by the adoptive parents or anyone else. And 6. Child cannot reject adoption. The child cannot reject the adoption and return to their birth family. The Hindu Adoption and Maintenance Act, 1956 applies to a large number of people in India, including 1. Hindus of all sects, including Vaishnavas, Lingayatis, and followers of Arya Samaj. 2. Jains, Sikhs, and Buddhists. And 3. Anyone who is not Muslim, Christian, Parsi, or Jew. No, the doctrine of relation back is generally considered to be not applicable under current Indian law, particularly in the context of Hindu adoption, as the Hindu Adoption and Maintenance Act, HAMA, of 1956 effectively abolished it by stating that an adopted child's rights only accrue from the date of adoption, not retroactively from the date of the adoptive parent's death, essentially negating the relation back principle. Key points about the doctrine of relation back in India. 1. Previously applicable. Before the HAMA, the doctrine of relation back was used in Hindu law, where an adopted child's rights were sometimes considered to relate back to the date of the adoptive father's death. 2. Section 12 of HAMA. This section explicitly states that an adopted child does not divest any person of an estate vested in them before the adoption, effectively removing the relation back concept. And 3. Limited application in other areas. While the doctrine of relation back is largely considered defunct in adoption cases, it may still have limited application in other legal areas like amendments to pleadings under the Code of Civil Procedure, depending on the specific circumstances.